All right, we're on. So, hey guys, this is Brandon Feco and Chris Smith here to talk a little bit about title and different options of how to hold title when you are buying a house or even refinancing, and what those different ways are, what's the advantages, disadvantages. So, you all know Chris, he's our attorney, and he specializes in things like this, LLCs, title holdings, amongst many other things. So Chris, why don't we kind of go into the details on what are options of when I'm going to buy a house, and let's just start with if I'm married. What are my options of holding title? Like I know there's joint property, there's community property, and it's often confusing on what the differences are between
Right.
those.
So the community property that applies if your state's a community property state, right? So,
Gotcha.
you and I work in California. California's a community property state. So the most common way that I see property titled between a husband and a wife is as community property or as tenants in common, which is the way you really want to do it is you want it held as community property if it in fact is. In other words, if it's not someone's separate property, take it in community property. And the reason for that is that between husband and wife, you want to get the full step up in the basis for capital gains purposes.
When you say step up in basis, just so everyone knows what you're talking about,
Right.
do
So
you
let's say
mean- Yeah,
let's say
go
you
ahead.
buy the house as
Yeah.
husband and wife, and you pay $100,000 for the house.
Okay.
And now it's worth $1 million, and the husband and wife are in their later years. And let's say the husband dies. So the original basis is $100,000. So if you sell the house with $100,000 capital gains basis, you're going to have to pay taxes on the $900,000 profit. But when a husband dies and you get a full step up in basis, now the basis is $900,000. So wife can sell the house with no tax liability owed, and she can use that money. Maybe she wants to downsize, go live in a retirement community, something like that.
So if you just held a property as community property, would that give you that step up in basis, or do you have to add right of survivorship to the end of that?
Well,
Does
you
it
can
matter? What's
add
the difference?
you can add right of survivorship, and the reason people do that is to avoid probate.
Gotcha.
But there's a lot of unintended consequences that we see when you hold property with rights of survivorship. Between husband and wife, maybe you keep it simple and that's fine. The preferred way of doing it is owning it in your living trust.
Yes.
Right, because now you have complete control over how property transfers, whereas the government is controlling the right of survivorship. That's that's going to be subject to statutory law or various things that the government can do.
So if your property is not in a trust, one way or the other, it's going through probate. Is that correct?
Unless you have right of survivorship, right? So
Unless you have right. Okay.
So you could have joint tenancy,
That's
which
Uh-huh.
gives you the right of survivorship. So what I've seen with joint tenancy is, let's say you and I want to buy a house as a rental property,
Mhm.
and then we take it as in joint tenancy, and you die. Well, I now own the property outright. So your wife would lose any she has no interest in the property, right? So she loses
Yes,
rental income.
and that's what joint tenancy does. It goes, I die, you
Right.
get the whole property. So let's say we wanted to invest without any kind of LLCs or trust or anything. How would we title it so my wife gets half upon her killing me? I mean, me dying.
We do it as tenants in common,
Tenants in common. Okay.
right?
So you don't
So
have to be married for tenants in common. That's more community
right
properties. If you're
now,
married,
right now
tenants
the
in
problem
common.
with tenants in common,
Probate.
now we have to probate the property.
Oh. Is there a tenants in common with right of survivorship? I guess not, huh?
But that gets us. It really isn't. It's just joint tenancy. But as
Okay.
soon as you have that rights of survivorship, unless your wife's on title, she won't have any interest in the property at death, right? So if you die, you're basically disinheriting your wife,
Yeah.
which usually you don't want.
No, not really.
Now I've also seen it where probably the worst case scenario I saw was a multi-generational situation where there were grandma and grandpa, mom, daughter, and they were all on title as joint tenants.
Mm.
The expectation was that grandma and grandpa would die first,
Hmm.
and then mom and daughter would own the house. But that wasn't going to happen, because when, let's say, grandpa but dies first, that basically leaves grandma, mom, and daughter on title, right? And there's an automatic transfer. But the thing that happens on that transfer is the joint tenancy is severed, which
Hmm.
means it no longer exists. So when grandma dies, now you have to probate the property.
Oh, wow.
The other thing they never thought about is, what if mom or daughter dies first?
Yeah.
So let's say daughter gets in a car wreck and is killed. Well, she has a husband and she has 2 children.
Hmm.
They just got eliminated from any ownership interest in the house.
Hmm. Yeah.
So I'm always going to recommend owning a personal residence in a living trust,
Makes sense for
because
sure. Yeah.
it gives you control. You're not guessing about who's going to die first. You don't have to deal with cleaning things up after someone dies, or it's just clean. So
Okay.
basically, you take ownership. So you're married, you're going to buy your house. You would take ownership as, husband and wife, as trustees of the husband and wife revocable living trust.
Hmm.
And now the trust document controls the ownership of the property. So let's say husband dies, wife becomes the sole trustee, and she can now do whatever she wants with that property. She doesn't have to go to court. She doesn't have to probate it. She owns it. And she can decide on her death that she wants that property to transfer to, let's say, one of her kids.
Okay.
And that transfer will take place without probate.
Got
Right.
it.
So
Mhm.
you're going to spend, a few $1,000 to set up a living trust. You'll spend a little bit of money over the years to maintain it, update it when it's necessary. But for that, you've avoided this whole issue of joint tenancy and who's going to own it, and how's, are we going to have to probate it, or are we not going to have to probate it? So, our multi-generational example, there's a couple ways you could do it. One is, you could have everybody own a fractional interest in the house, and each of them have their own living trust. Or what you can do, because grandma and grandpa made the down payment, they could take ownership in their living trust, and then, update the trust so that on their death, the property belongs to mom or to the daughter or to both, right? So you can do whatever you want with it in the trust. You just have to sit down with a lawyer and draft the
So in
trust.
that case, it's just held in the grandparents' trust, and then they designate what happens upon their death.
Yeah.
Is
So
that
the
correct?
vast majority of trusts that I draft for husband and wife, they're going to put the house in the trust. And then the trust has whatever provisions that it has. Usually, the expectation is you're going to leave most of your property to the kids or a charity.
Yeah.
And
Now, can you put the house, like, let's say you and I want to buy a property together. I'm going to live in it. And so it's technically owner occupied. This is just, theory, whatever.
right.
I have a trust. You have a trust. Would you have 50% in your trust, 50% in my trust? Like, what would that look like? Let's just say.
Yeah, it depends. Yeah,
And
let's
of course,
say
you're my relative, we would say. So that
okay.
way it would be owner occupied.
So let's say that you're going to live in it. That our deal is we both own 1/2 interest. So on the deed would be to Brandon Feco 1/2 interest as trustee of the Brandon Feco Trust, and mine would say Chris Smith's 1/2 interest as trustee of the Chris Smith Trust.
Gotcha.
And
that is possible.
And so, yeah, so now I own a 1/2, excuse me, a 1/2 undivided interest in the property.
Okay.
And you own a 1/2 undivided interest in property.
Mm-hmm.
Now, the other piece I'd put in there is a lease agreement that you're going to agree to pay a certain amount in rent every month. Right? Because if you're living in it and you're not paying rent and the mortgage isn't getting paid now, neither of us are going to have a house because it's going to get foreclosed on.
Yeah.
Right. But yeah, no, you just put it in your trust, and then you can say, in your living trust, after you transfer the property, you want to update the trust, and you're going to leave your undivided 1/2 interest to maybe your wife or to someone else, or maybe what we do is we have an agreement that when one of us dies, that these other can either buy your half interest, or we just sell the house. And especially if you're the one living, maybe we just sell the house and be done with it, or maybe you want your spouse to be able to live in it after you're gone.
And that's the advantage of having a trust. You can do whatever you want to do upon your decease.
Yeah,
you could lay it all out there, and this is, I want a quarter to go to this kid and another quarter to go to this relative, whatever you want.
And that
it's hard to do that with just title, huh?
Yeah, so people get confused when they hear the word estate planning. What they think that is you're buying some documents, but it's actual planning. You sit down and you plan things out.
Yeah.
And then
that makes
if
sense.
you can write it, you can make it happen, as long as it's legal.
Okay.
You can't do criminal stuff in a trust. You have to follow the law. But the the idea is put the property in the trust. It makes there's no difference from a tax perspective. It's not going to hurt anyone from being reassessed or anything like that. You can transfer into your living trust without risking the loan being recalled, and that's true anywhere in the United States. You can transfer into your living trust without worrying about California reassessing the property for property tax purposes. And just make sure it stays in there. Now, this from personal experience. You'll refinance a property through a residential lender, and they'll want to transfer the property out of the trust.
Yes.
And then do the refinance.
Exactly. Now, some of my lenders will allow me to close in the trust. Some don't. And I'll have to put it back in after the refi, which is a pain. I actually did that to myself when I refinanced myself. I realized afterwards it was no longer in our trust, so I had to go, put it back in myself.
Right.
Um,
And it's a headache because not
yeah.
only do you have to do the deed, you have to file,
Hmm.
fill out the preliminary change of ownership report.
Yeah.
You got to make sure it's filled out so that it doesn't trigger a reassessment.
Correct.
You got to get it filed uh, and recorded, and all that stuff. But
Yeah. Luckily,
um,
I'm in the business and I have escrow and everybody kind of saying this
right,
is how
and
you
I
do
use
it. So I could just do
yeah,
it myself, but I wouldn't recommend that for most people.
and I use
Um,
a service that takes care of it.
okay, cool.
And I use it as separate service that um, I I can get deeds done anywhere in the United States.
Nice. That's
Yeah,
awesome to know. Cool.
yeah. It's basically a national a
You
national
getting
wealth.
phone calls there, buddy?
I am,
They're
and
blowing you up. They're like, I want it
they're
my trust.
they're not giving up on me, man. Anyway, so yeah, if your property ends up out of the trust, you just have to put it back in. It's going to
Yeah.
cost you some money, a few
Few hundred
$100,
bucks, right? You
and
typically. Hmm.
yeah, and but it's worth it. It's
Okay.
worth spending that money because if something happens, we're going to avoid all of the headache of probate of dealing with it.
Yeah. So, I mean, a lot of my clients typically, are closing not in a trust. They don't have a trust. Um, if they're married, I guess it's normally going to be community property out here in California. Is there any reason why you shouldn't have a trust, or is it just, why are people not getting trust? Why are they not closing in trust? Is it just because they don't know? Is it obviously it's cheaper to not have one, but maybe not in the long run? I
But
don't
no,
know. Like,
it's
go into
in the long
detail.
run, you're going to spend a lot more money,
Yeah.
assuming you leave property behind. Uh, so I, I think everybody who you could do some basic planning, like if you're 18 years old or early 20s, you do some
Mhm.
basic planning because you probably don't have a whole lot of stuff,
That was, yeah, that
right?
was my next question. What if you don't have kids? What if you don't really have much of a family,
Right.
or you don't
So,
care where your property goes? I don't
well,
know.
if you don't
I'm sure
care,
that's
then
not in most situations, but
so most of us have somebody
yeah.
who's going to have to clean up the mess when we're gone. And so, even if you don't have kids, you still do the trust because you don't want to leave a mess for someone else to deal with.
Okay.
Right? You want to do a little bit of planning that says, when I'm gone, or if I'm incapacitated, this is the plan,
Hmm.
and you need to document it so that you don't end up in court arguing with lawyers and other people about what the plan was. So that's why we do the trust.
Got it.
But even if you don't have a lot of stuff, if you have responsibilities in life, you should have a trust. So one of the examples that I give in that case is I had a friend, a young lady, single mom, and I told her, you really should let me put a trust in place for you.
Hmm.
And she laughed and she says, Chris, I don't own anything. I rent an apartment and
Hmm.
I've got this beat up old Prius and maybe like $1,000 in the bank. And I said, well, you have a 5-year-old kid. So what's going to happen to your 5-year-old child? And she says, what? He gets to inherit the Prius? I said, well, why don't we sit down and do some planning? Because we could probably leave your child with $500,000 or more through life insurance.
Hmm.
But you don't want to just buy life insurance and make your 5-year-old the beneficiary because he's 5 years old.
Yeah.
You know, and what happens then is that money ends up going into a blocked account, which you need a court order to access the funds. So every time you need something for the child, you have to go to the court and get a judge to sign an order that directs the bank to release funds.
Wow.
Which is expensive.
Yeah.
Also, it's in a bank where it's earning like no interest. So it's not growing. It's just dead money. So you don't want to leave life insurance proceeds to a young child. And even if they're over 18, now you have the problem of an 18, 19, 20-year-old who gets $500,000. What are they going to do with it? It depends on the 18-year-old, but my decision-making ability at 18 was not that great. I probably would have had a lot of fun for a couple of years and then have nothing left.
For sure.
So you set up the trust, and the life insurance gets paid to the trust, and you have a successor trustee in place so that if something happens to mom, the trustee now manages the $500,000 on behalf of the child. So even though she doesn't have anything, she has responsibilities, and so she can address those and take care of her son. If you're young and you're thinking about getting married, you should be thinking about having a trust, because once you get married, you have responsibilities. So you're going to want to acquire some life insurance, have that paid to the trust for the benefit of your spouse, and if you have kids, if you're buying real estate, like a home, you want that owned by the trust. There's really no reason not to have one, because the price points I see on a what I call a comprehensive estate plan, for a few $1,000s, you can get a pretty well drafted plan, and you can update that plan at any time. So as life evolves, maybe you get more kids, maybe your kids grow up and become adults, and maybe you buy more property, maybe you start a business. If you start a business, you better have a plan, because once you start hiring employees, they're depending on you for their income. So if something happens to you, what's the plan for them?
Yeah.
Right. And if you're in a unstable employment situation, you're probably going to leave. So you're going to start losing your best employees, because they can leave. And so then they can go work for someone else who's done that planning and is stable. Right. So, we go on here for a while about all the reasons why using a trust is pretty much, in my book, mandatory. If you're going to be a responsible human being and take care of the people in your life, that's what, like, the primary tool, right, that we're going to use.
Makes sense.
So, cool. And the other mistake people make is, they don't update it, or they want to use. I mean, I've seen like the legal Zoom trusts and stuff like that. They're designed for everyone, which means they're designed for no one.
Got it. You kind of like a template, like cookie cutter. You can't really personalize it very well.
Yeah, you fill in the online form, and it generates the document. There's nothing wrong.
Not to mention somebody like you that has been doing this for years. You're going to sit down with me. You're going to find out what's important to me.
Then we design the solution, like my single mom friend who didn't think she had anything to leave her son. So
but you actually got her thinking, and you show her, like, you're not actually, the way you're going about thinking isn't quite the best way for your future or for your kids' future. So
and for most people, should be included, is this is not a conversation you usually have when you're in your 20s or 30s, and you're not thinking about your mortality typically.
No, in our 20s we're invincible.
Yeah,
At least I was.
yeah. Well, we all were.
Yeah.
It's when you I mean, a lot of my clients come to me for some planning when they're, older, in their 60s or 70s.
Yeah.
And it's like, where have you been the last 60, 70 years?
Hmm.
Um, and and when I do that, it's it's good. I mean, it's good that they're doing it,
Yeah. Better
but
late than never, but start earlier.
right. So, but I see all of the opportunities. If anything had happened to them earlier,
Hmm.
you know, you'd have a disaster.
Yeah. That
And
makes sense.
and I've seen that. Uh, Cleaning up that is tens of thousands of dollars.
Mm.
You know,
Uh,
you're probably going to spend quite a bit of money depending on how often your lawyer and personal representative need to go to court, because now you just died intestate,
mhm.
which means that your estate plan is now by default written in the probate code.
Yeah.
So the way that works is the judge will require that the personal representative, or they call it an executor as well, and the lawyer contact all of the creditors. And the creditors then submit their claims
Mm.
against the estate.
Okay.
And the judge will then, quotes, marshal the assets and use the assets to satisfy all of the creditor claims.
Gotcha.
And then after all the creditor claims have been satisfied, then they'll look at what's left and look at the probate code and say, all right, this is where this stuff's going to go.
So in a trust that does that kind of work the opposite? Like the assets go to whoever they're supposed to go to, and then what about the debts and stuff? Out of
Well,
curiosity.
the estate has to settle the debts, but
It still will. Okay.
right. But now what's going to happen is, you're working within the context of the trust, and you know maybe you have a mortgage on the house, right? Maybe you don't want to uh, completely satisfy that. So you're going to service the debt,
Hmm.
right? You'll make the mortgage payment. You're not going to sell the house to do it. And then the trustee will do whatever they need to do. Perhaps it's necessary to refinance. But quite often the loan's assumable
Yeah.
and it's already owned in trust. And
Typically FHA, VA, not conventional, but
yeah,
they can
and
be. Yeah.
so then you just keep paying the mortgage payment. And if the lender's not going to call the loan, everything's fine.
Hmm.
Uh, the if it's in probate, that house is gone,
Yeah.
right?
They're
So
made to sell it and
right,
sell
so
everything out.
yeah,
And I
so
mean,
you have a lot of options.
I've seen property get tied up in probate for months and months and months. I mean, what's the longest you've
Well,
ever
and
seen a
the
property
worst
get
part
tied up?
is when it's in probate, you cannot sell it.
Yeah.
Well, you can, but you have to comply with a rule set, and it's very restrictive.
Hmm.
You can't refinance it.
Okay.
Um, you can't do anything with the assets until they've been processed by probate.
Yeah. Okay.
Right? In a trust, you can do whatever you want,
Yeah. All right.
right?
Well, cool.
And
So, bottom line, moral of the story, there's no reason to not have your property in a trust. It's just you're doing yourself a disservice. You're doing your family a disservice.
yeah,
So,
if
pretty
it's
much
your
everyone
residence, if it's your
should be in
personal
a trust.
residence,
Hmm.
put it in trust.
Okay.
Uh, there's no reason not to.
Okay.
Now, if it's a rental property, then last time we talked about using a limited liability company.
Yeah. Mhm.
There's other solutions. You
Now,
may not.
would you have a limited liability for an investment and then the trust holds the LLCs in the trust, or how does that work?
Yeah,
Is that, yeah,
yeah,
okay.
you can own the LLC in the trust. You can make your structure for your businesses as complicated as you want.
Yeah.
I like to keep it simple. I've seen some pretty convoluted uses of LLCs. I've seen people who had like 6, 7, 8 LLCs, which is usually completely unnecessary.
That sounds like if you're doing something illegal.
Well, not necessarily illegal, but I've seen people, they get an idea for something and they form an LLC because it's super easy to do.
Yeah.
And there's not a lot of thought or planning taking place. It's just kind of a knee-jerk sort of thing, or they go see something on the internet, or they go to a weekend conference and they say, you should have 6 LLCs, each one for one of these things, right? And next thing you know, they're filing articles of formation, and often it's in jurisdictions like Nevada or Wyoming or maybe Delaware, and there's no reason for it. So I just had a conversation with a guy who set up. He got a Wyoming LLC. He doesn't live in Wyoming. He doesn't do business in Wyoming. And the reason he said he did it is because Wyoming has pretty good privacy protection.
Mm-hmm.
So that's great, except when you're in business, you don't want to be private. You want everybody to know you're in business.
Yeah.
So there's no, you're defeating your own purpose, with that's because you want to go get clients. You want to bring clients and customers in, and you're going to make a lot of noise about it, and you're going to draw a lot of attention to yourself to do it. So now you just increased your cost of maintaining that entity, because you have to have it admitted to your home jurisdiction as a foreign entity, because that's where you're doing business.
Yeah, exactly.
Right. So now you have to pay the Secretary of State in 2 different jurisdictions.
2 different states, yeah.
You got to comply with the requirements of both jurisdictions. You have to have registered agents in both jurisdictions. So you just doubled your maintenance expense.
Yeah. Yep. When I did my first company ever, I filed in Nevada for some reason. And then I had to, get my certificate of good standing in California and set everything up in California. It was more of a hassle and more money. So it just didn't make sense,
So where it does make sense is,
time ago.
if you're using it as a holding company, it might make sense.
Yeah.
If you're going to buy an apartment building, maybe you want to buy it in an LLC, and maybe you want to use Wyoming to maintain privacy so that people don't know you own an apartment building.
I see. Yeah.
Right. But
because sometimes people see money and they may want to do some things to get your money. So.
Right. And there's other ways to protect yourself from that as well.
Yeah.
But the primary residence, though, just put it in your living trust, and and you're done.
Cool. Yeah, I think you answered all my questions. I mean, the if you don't have a trust, what are all the ways you can hold? You said joint tenancy, community property.
Yeah, so there's
tenants
in common, and this is going to differ from one jurisdiction to the next. They'll have different words, but tenants in common.
Are you saying, like, depending on the state you're living in? Is that what it is?
Right.
Or okay,
right,
gotcha.
So if you hold it as tenants in common, what that's going to do is you're going to have to probate the property, and you're going to get a single step up in basis.
Yep.
And then the ownership with tenants in common, you can transfer your interest with a will, right? But it still has to be probated. Wills have to be probated.
Gotcha.
Joint tenancy avoids probate through the joint tenancy. So basically, whoever is the survivor on the joint tenancy, they're going to own the property outright, and
Yes.
they'll have to clear
Which
title.
which can again, which that could screw over my wife if you and I had that property together. I die.
It causes problems. Plus, you
Yeah.
just
You
get a
no
single
longer.
step up in basis. So in our example, we said we bought the house for 100,000 and now it's 900,000 or I'm sorry, $1 million. You're only going to get a 1/2 step up. So you've had a $900,000 appreciation. Your property basis will get stepped up by $450,000. So your basis is now $550,000.
Okay. So then if you said, well, Brandon died, I want to get rid of this property and sell it because I don't want to own it on my own, you're going to pay taxes on whatever, $450,000.
Yeah, you might have to pay capital gains taxes on the, on the 1/2.
Yeah. Versus if you get the full step up in basis, that property is worth $1 million. You sell it, you're technically not really liable for any taxes on that, correct?
Right. Now, if the property is being owned by two spouses, you have the choice of owning it as community property. You can fast track a community property, when the first spouse dies, but it still has to, there's still a process that needs to take place. You get the double step up in basis, so surviving spouse could sell the property with no concern about capital gains. And ownership can also be transferred via will. And but again, you're back in the courthouse trying to get the will probated.
So, yeah, and I could see that's a perfect segue to I could see a lot of people saying, well, why do I need a trust? I have a will. And that is a good explanation. So even with a will, it's still going to go to probate. It can still get held up. So the trust can completely avoid all that. Yeah. And you just have way more control.
Yeah. So the way I describe a will to people is the first thing you need to understand. A will has absolutely zero effect while you're alive. The only time a will works is you're dead.
Okay.
Right. So it does nothing for you during your lifetime. And then I describe it as a letter to the judge. So you're going to make your last will and testament. It gets lodged with the court. And the probate process goes exactly the way I described before. The judge doesn't care what's in the will. His job is to first get the creditors all paid. Once the creditors are paid, whatever property's left over, now they'll read the will. And they'll distribute property to the extent they can according to the terms of the will. So if you said in your will, dear judge, I'd like to leave my house to my nephew. Well, maybe that house got sold in order to pay off the mortgage. Right? Well, sorry, nephew, you're not getting a house because it's no longer part of the estate.
Yeah.
So, the thing to understand about a will is the person making the decisions will be a judge, and we don't know who that is. It's whoever's sitting in the courthouse that day, right? And but if you use a trust is active the moment you sign it.
Okay.
So that trust will operate, while you're still alive.
I see.
Now, when you're alive and competent, it's not a big deal because you're able to do with your property whatever you want to. But let's say you become incapacitated and you can no longer make decisions about how to live your life. Your trustee, you can have a successor trustee then who manages the property for you. So your money stays invested, the bills get paid, everything operates the way you lay out in the trust. And then when you do die, the person making decisions about what happens to all your property is somebody you've chosen, and who's you got the trust to guide them in terms of how to manage things. So the way this looks is I just did a trust for someone who has like 4 or 5 kids, and her primary asset is a house. So what happens to that house when she dies?
Mm-hmm.
Well, we walked through a few scenarios. One was the house gets sold and the proceeds divided between the kids. Or maybe the house is maintained in trust and the trustee is given the authority to rent the house. Well, what if one of the kids wants to live in the house? Well, that's okay, but they still have to pay rent
Mm-hmm.
because it has to be fair for all the kids. So if Joey decides to live in the house, well, Susie and Timmy and Betty are, they got a raw end of the deal because
Yeah, that makes sense.
So you have them pay rent, and you take fair market rent. So let's say it's $4,000 a month, and they pay $3,000, but then they're not entitled to any cash flow from that $3,000.
Yeah.
So basically, all the kids will get $1,000 each month, less expenses.
Okay. Cool.
So, but you can set that up in a trust, no problem.
Yeah, that makes sense for sure. All right, man. Well, I think you answered all my questions. If anyone else has any questions, feel free to comment or shoot me a message. And I highly suggest talking